Thank you very much for having me here today. And I have to commend Petra and Heidi for your having held the conference about the future and having even a panel about sports arbitration. And no one today has mentioned the famous line of the American baseball player Yogi Berra, who said, "The future ain't what it used to be." I mean, I think that, so I wanted to ruin it by being the first one at the conference to use that line. Although the topic of my presentation today is the future from a user's perspective, I'd like to discuss for a moment the golden age of arbitration. And when I say the golden age, I think you all know what I'm referring to. It is that time when arbitration was peaceful and civilized, all arbitrators were above average, and everyone was happy. And by everyone, I mean men of European descent like me. Now, you didn't really think I meant everyone. I meant everyone in this sense. And when we look back, I think, on the golden age of arbitration in perhaps 20 years, I actually think that the golden age of arbitration that we'll be referring to then will be 2018, or certainly to include this period. Whether we'll be arriving here in Helsinki via our Uber air cars or complaining about the fact that we had to pay for a seat to sit down on the airplane that brought us here. It depends on whether you see the future as rather idyllic or dystopian. I think in any event, we will look back and we will look at a time when arbitration was quite incredible. It was a time before technology took over and ran everything in the arbitration. It was a time when arbitration institutions were introducing innovative rule changes at a pace that it was difficult for many of us to keep up with. It was a time when there were new services just coming in and starting to shake up the practice of international arbitration, like arbitrator intelligence, a project that Professor Catherine Rogers has promoted, or there was an industry trade press just beginning to really take hold with like the Global Arbitration Review. It was a time when, incredibly, there was a sudden diversification of arbitrators and of the Counsel, where we saw a much larger ingress of arbitrators, women arbitrators, and to a lesser extent, but still happening, also geographic diversity began to make its way into arbitration. So I think in the year 2038, 20 years from now, or 2045, whenever you decide to host a similar conference looking back, I think we'll look back and we'll see 2018 in this period as kind of, as an arbitration community, we'll see it as the equivalent as how people of my generation tend to look at the 1960s. This wonderful, creative, flowering period, considerably less sex, drugs, and rock and roll, because this is arbitration, but we will look back on it as really a flourishing time. And it will continue that way, of course, until 2075 or 2080, when, of course, they will then look back on the period of 2038 and say, that was the global age of arbitration. I make this point, actually, to follow on comments that both Heidi and Petra made this morning at the introduction, that arbitration is always going to change. I think we'll always be looking back at how it was different, in some ways better, some ways worse. But really, it's going to be a constantly changing process. And what I would like to imagine, again, the evolutionary pressures, the users' pressures that we bring to bear as the forces of the market, to imagine how we, the users, and by users, I mean really not just us, corporate counsel, but I think is the way you referred to it, really the people who are applying pressure on arbitration institutions. Over the last 2 years, 2016 and 2017, I had the privilege to be the chair of the Global Pound Conference, a conference that was held around the world in 28 cities, and where we asked the same 20 questions to over 2,000 people, judges, arbitrators, mediators, institutions, ministries, counsel like myself, outside counsel. And the interesting thing that all of us said, or the responses came back rather consistently, is that the view that the users were the ones who were most likely to drive change, the parties who had the biggest input into the arbitration process, meaning also the companies, the innovators who are out there. Interestingly enough, Stavros, who was here this morning, we were talking about this earlier, the Queen Mary survey does not provide the same data. The respondents to that survey said that most people think arbitration institutions are the ones, and it was like 80% felt that arbitration institutions are the most likely to effectuate change. But I think actually, Heidi, in your presentation this morning, I think you said it right, that I think we're saying the same thing, because the institutions will be looking to the market, and it's the users who will be driving the market. So in thinking about the future, and I've spent a fair amount of time in preparing for this, thinking about what will the future look like, I realized it's not going to be people like me who will drive it. We need to think about who will be the users over the next 5, 10, 25 years. And what I'd like to do in thinking about, well, first let me tell a little about myself, and I think people of my generation. I'm 55 years old. When I went to university, we didn't study international arbitration. We might have been exposed to some domestic arbitration, but we mainly learned about arbitration through our own mistakes, by bumping into things and saying, well, that's not the right way to do it. And we perfected it almost through experience. The generation that is now coming forward and taking over and coming into power is, to me, represented by, actually I can give you examples. There are two of them who are here in the audience today. One is Oskar Toivonen, who's a Finnish, and the other is Maria Tater, who's Estonian. Both of them were interns with me in my offices in Florence. Both of them have by the time they graduated from university, they already had a very strong understanding of what international arbitration is. They both also participated in the Vis Moot, where they gained incredible practical knowledge. By the time both Maria and Oskar started to work for me in Florence, just shortly after they finished their university studies, I think they knew more about international arbitration than I did 8 to 10 years out in my career. So when I look at the current generation, the people who are going to gradually come in and replace people like me, I'm very excited because I have to say, and this I'll use my crude California jargon to say, they really kick our butts. They are amazingly more prepared, and they share many characteristics among them. And I think many of you, of course, will know them. You all know Oskars and Marias, or the equivalent of Oskars and Maria. They are the people who they trained or they studied in one country. They may have trained and qualified in a different country, and they may end up practicing in a third or fourth country. They are, by their nature, highly informed about the processes and the options that they have in front of them. They are multicultural, they are multilingual, they are very adaptable. They're highly networked with each other. One of the things that has really, I find incredible, is how quickly and how easily information among this group, this generation, travels around, and how connected they all are with each other. I think that they are highly flexible in their use of the tools, of the dispute resolution processes that are put in front of them. I think they have a desire, I think they can move, in being flexible, I think this is a generation that knows mediation as well as they know arbitration. They can move just as quickly from one procedure to the other if they think that one of those procedures fits better to their client's needs. I think they have a desire for faster outcomes. And very importantly, they are not threatened by technology. They're embracing it, and they will drive forward the use of it where they find that it makes a substantial difference in the interest of their clients. On top of this, I think the users that we have to consider for the future, and I think this is just a fact, the super users are going to be third-party funders. And the third-party funders are people who see how arbitration as it's conducted across the world because they have portfolios. They're constantly seeing what works and what doesn't. So to me, the third-party funders are basically the Oskars and the Marias, but on steroids, because they have this super visibility as to things that are going on, and they're not afraid about trying to drive change. They will exert an incredibly powerful force on institutions, on all forms of dispute resolution to be better, to be faster, to be more efficient. So, thinking about not people like me, but people like this generation and third-party funders coming into power, the seats of driving, being the drivers behind the market, what are the things that I think might happen over the next, I'll give you segments, predictions as to 5 years, 10 years, and then 20, 25 years. I think my predictions for 5 years are pretty accurate because they're based on things that we're already seeing. That I think is relatively easier to gauge. 10 years, we have to begin to make some educated guesses. And then looking 20 years out, I'll just give you a couple of big swings because I feel I'm not so much tied to today. There's so many things that might happen. Over the next 5 years, what I would predict is going to happen, and then what people like me are going, or in my position, will help drive, is that we will push to a divide or a split between low value, low complexity disputes on one hand, and high value, high complexity disputes on the other. And I think institutions are going to respond to that, number one, because they have to keep us engaged, to have our attention. They're going to have to be there where the big volume disputes are, and there are a lot of them. And we can't continue in a world where, I mean, for a business, 100,000 euros may be a lot of money, but you can't spend 80,000 or 150,000 to resolve a dispute for 100,000 euros. So I think that we'll begin to see this split, where today, even many disputes today that are not even being decided, will be decided increasingly by processes that are being developed, and it may include a fair amount of online dispute resolution. Now, importantly, this is not necessarily online dispute resolution that will be better than humans, online, doing traditional ways of doing it, but this will be better than nothing, because we will need to get these disputes resolved. So again, sometimes when we think about technology, we think about comparing technology with how good human beings are, or what we can accomplish with human beings. I think sometimes we have to compare technology in situations where there is no other alternative. And I think that's where we're going to begin to see this use of technology to help us resolve the lower value, lower complexity disputes. I think also over the next 5 years, I think we're going to see some compromise in party autonomy, in the fact that everything that the parties want is the parties are just going to get. I think we've begun to see that a little bit with the ICC, with the new rule that was introduced last year, that basically you've agreed that if the dispute is under $2 million, you don't care what the parties agreed in their contract. They're not getting 3 arbitrators, they're just getting 1, more or less. Well, that's what your rule says. But I think users are going to come to like that. I think some people may object at the beginning, but users want results, right? We're less concerned about the process. We're more concerned about getting these cases over and done with. And I think that once that concept sinks in and we see that sacrificing some party autonomy in favor of getting some good results, I think that we'll come to like that. And I would expect to see other compromises in party autonomy to keep the process moving forward. And another aspect of process I think that we're going to continue to see is the greater rise of mediation to complement arbitration, to intersect with arbitration. Because it's just, we're seeing that, we saw that, by the way, in the Global Pound Conference, that there was a high demand by multiple stakeholder groups around the world that when you come into a dispute, you should not be trapped into only one type of dispute process. You should have multiple options, and the disputes, again, I think this is more for the larger value disputes, but there should be more customization as you're allowed to go down the path of the dispute. And again, I think arbitration institutions will increasingly have to offer mediation to be an ancillary service to a company and to sell also the arbitration service. I also think over the next 5 years that transparency is going to blossom. I think we're beginning to see it with the likes of arbitrator intelligence. We also have the Global Arbitration Review has an arbitrator database that they're now offering, which, by the way, not to criticize, but I think it basically takes a questionnaire that I and 2 of my co-authors, Emma Vida-Gojkovic and Lucy Greenwood, wrote some years ago, proposing puppies or kittens, which we said that arbitrators should just tell, like you should make a selection of whether do you prefer puppy or do you prefer kittens? Well, I want to know that for an arbitration. We suggested these sort of soft skills that arbitrators often have as to whether or not they like expansive discovery. Do they like limited disclosure? Do they like to use arbitral secretaries? Some of these aspects of how they manage or their case management processes would make it easier for us to appoint them if we knew that rather than try to guess it or to divine it through contacts that we may have, word of mouth, or just making stereotypes based on their place of study or their national origin. So we're beginning to see more transparency. And interestingly enough, the Queen Mary survey, I think, also highlights this tension that we see today, where if you look at the results, 43% of the respondents who were in-house counsel said, we do not have enough information about the arbitrators that we appoint. That's almost half. I mean, that's a big number saying, as to the most crucial part of the process, appointing arbitrators, we lack information. So I think eventually, over the next 5 years, institutions will begin to get comfortable with the idea that to be successful, they're going to need to provide that they have information about arbitrators, and that if they begin to make this available, more parties will come to them. I think regional institutions, I think, are going to, and I think this is one where, we spoke about this, through collaboration, getting regions to collaborate, to work together, we'll see again, businesses in Finland, if they get good service from a local Finnish institution, you will see a growth and a rise of the regional institutions. And I think that we're already seeing this. I think the statistics published by many of the leading institutions already show that arbitrations are beginning to move away from the traditional major centers. If you look at the data, even for the LCIA and the ICC, although London is claimed to still be the preferred place of arbitration, that's not what the numbers show about where arbitrations are being conducted. It shows London is relatively stable in the number of arbitrations. The growth is in the non-traditional places, the places that 10 years ago people just were not arbitrating there, and today they are. And I think that we'll see more increase in the growth of the non-traditional centers. I think we'll also see more sharing of resources among arbitration institutions. I would expect over the next 5 years a very big sharing of resources that, again, to serve the needs of the users, to give us comfort, will be, for example, in areas like cybersecurity, infrastructure, that a small regional institution is going to find it very difficult to have the resources, to have the IT systems to guarantee the levels of security that people like us will demand. I would expect that you will probably achieve that by having some degree of collaboration through each other. And again, that will provide us with greater guarantees. Finally, over the next 5 years, the types of disputes that I would predict to grow, again, I concur fully with what the Queen Mary report says, that we will see a growth in energy and oil and gas disputes, that's the industry I come from, and also technology disputes. The Queen Mary survey doesn't give a lot of reasons for this, but to me, coming from the oil and gas and energy sectors, it is very obvious. These are technology, energy, oil and gas, are sectors where there are commercial relationships, collaborations that are very highly capital intensive. They are very expensive, and increasingly it's getting more expensive. These projects may take many years. It can take many years to develop an oil and gas field. It can take many years to invent or bring to market a new technology. It can cost tens of millions, or in oil and gas, billions of dollars to make these things happen. And at the time you sign the contracts, you have certain assumptions about the profitability and the viability of the outcomes of these contracts that may not be there by the time these things actually are brought to market, which gives rise, of course, to a lot of conflict that will need to be resolved. And I think we're going to see a lot more of that over the next 5 years. Finally, in terms of the next 5 years, Gary Bourne is a dear friend, and I think his text is wonderful. So I think that would be a great barometer as to the sort of materials that we will see developing. I consider Gary's treatise on our international arbitration to be absolutely wonderful. And I think I would predict that his next edition, it will be the 4th edition that will come out in 5 years. I'm just predicting. I haven't talked to Gary about this. And I think he'll have to add, it's currently 3 volumes. I think he'll have to add a 4th. To take into account the availability of information about arbitral awards, that we will begin to see an actual body of international jurisprudence that will emerge from the level of transparency that we will begin to see. By the way, just to comment on the former panel, I think that it's very important to distinguish confidentiality of procedure with respect to confidentiality of the awards. And I think parties like us have very different sensitivities to confidentiality as procedure. We don't want people coming into our proceedings if we can avoid it. Many of us don't care so much about the confidentiality of our awards. I think that's some industries that's the case, some industries not as much. The next 10 years, I think things will we're getting into a fuzzier area in predicting things. But I think that the split between low value, low complexity disputes and high value, high complexity disputes that will begin now and will spread over the next 5 years, over the next 10 years going forward, is going to be very interesting. Because what happens when in-house counsel, when we see something's working, when we begin to trust systems and say, well, look, this seems to be working for the low value disputes, what we will see is these systems will begin to creep forward more and more and more so that they will start taking on higher value, right? Because it worked for us in this stuff, why can't we stretch it and make it work out further? So we'll begin to see more use of technology to resolve disputes that are getting into the more complex, the higher value states. Not all disputes, but I think there'll be a fair degree even of artificial intelligence systems that may assist the aid of arbitrators. I think The use of artificial intelligence may even be adopted by arbitrators to assist them in order to gain appointments from us to show that they can manage complex cases. We may actually want or expect our arbitrators, not me, but the people who will come after me, will expect that from their arbitrators, that they should use these new systems to help them resolve these complex disputes. So we may see, for example, artificial intelligence tribunal secretaries. I think we'll also see for the human arbitrators, again, I think most arbitrators of complex disputes, or all of them, will continue to be human beings, or at least over the next 10 dozen years. But I think we'll see a push, again, from the users for what we would call professionalization. So we'll see certification, we will see licensing schemes. We'll see that in 10 years, again, the people who will come after me will say, I'm not going to hire a doctor to treat my children if they're not licensed. I'm not going to appoint an arbitrator in a case for my company unless they are also credentialed. I think that's a change that will probably happen over the next, I say beginning about 10 years from now. I don't think we're there today. I think the parties like me will be appointing counsel from less traditional sources. We're going to continue to unbundle, to disaggregate the way that we look at cases. We'll become more, the future people will be more project managers necessarily than lawyers, and they will know where to appoint the best lawyers for a particular type of case. If you're in Helsinki, that counsel may be in Helsinki, but they might also be in Paris. They might also be in New Delhi. And as a project manager, you will be able to find, and you will be networked, and you will know where to find the best talent for your cases. Finally, and the types of disputes, I think that energy and anything where there is big ticket discussions, a lot of collaboration over a long period of time for high value will continue to be the source of disputes. But I think over the next 10 years, we may also see new types of disputes getting into arbitration. Consumer disputes. Intellectual property. As we begin to see with ODR and technology helping resolve disputes, there may be even lower value, different types of disputes making it into international cases. Now, finally, I'd like to quickly conclude over the next 20 to 25 years and just take two very quickly big swings as to what we might accept to see. The line between human and machine arbitrator, and I think we're going to get there eventually. I'm sure that we will get there eventually, will become increasingly blurred. Users will start to want machine-assisted or even machine-rendered decisions at some point because it will be fast, it will be accurate. Whether we go full on with machine arbitrators, that I don't know, because it's just hard for me, from my generation, to imagine that. That's a question for the next generation that they will have to address. I think that the big problem that they will have to struggle with is not one of technology. I think the technology will be there. It's whether or not parties, users, will be willing to accept that a machine is responsible for an outcome that they don't like, right? I mean, I think that we always want to be able to blame someone, and maybe the need to blame other human beings for bad results may ultimately preserve the domain of the human arbitrator. I think that gender diversity will probably be achieved, for the most part, around in 10 years. I think I would have to predict that geographic diversity, I think, is harder. I think it's underway, but I would say, if I had to pick a date, I'd say about 20 years in the future we'll get there. And then finally, in terms of what's happened 20 years from now, I think Gary Bourne's treatise on international arbitration will no longer be a book. It will be an artificial intelligence in Gary's voice. You can ask it any question, and it will instantly give you an answer based on all of the cases that were decided in arbitration around the world today. And if you wanted to look even forward after that, I guess we would see a future where in maybe 50 or 100 years, those who are still, well, maybe will not be around, but those who will be around, well, when they're appointing arbitrators, will actually have to decide, do I want a Carito, Wahlgren, Lindholm flavor arbitrator? Or do I want a flavor of arbitrator like a John Beachy or some other well-known arbitrator that you will be able to choose, and the type of arbitrator that you want from systems that are designed to help you resolve disputes? Again, this is a big swing about the future, what may come, and the people who may come after us may actually strive towards. I'd just like to close, however, by taking us back to today and the golden age of arbitration, and suggest that we all enjoy it while we can. Okay, thank you.